Mr. Nitin Thakkar, President of the Bombay Bar Association, Mr. Naushad, the engineer, Secretary of the Bombay Bar Association, ladies and gentlemen, thank you all for coming this evening for our AI Unboxed session, a session on how we hope to impart knowledge on how to use AI safely and effectively. I am not the one who's going to conduct this entire session. I am going to take your leave very soon. But I have been given the big responsibility of honoring all those on the dais with a token of our appreciation. May I request Mr. Thakkar, please, kindly to give Saloni Kapadia, partner at Cyril Amarchandan Mangaldas, for being here and for sharing her knowledge with us. Thank you. Thank you, Saloni. Now, Vinodini Srivasan, correct, Vinodini? Yes, council member of our association, thank you so much. She is an AI master and she's going to teach us tricks of the trade today. We also have with us Viraj Parekh, another council, very well established AI master. And on behalf of Lex Legis, may I request Mohit Motani kindly to please accept a token of our appreciation. And last but not the least, a fellow committee member, the one who's going to take over from me, Ankita Singhania, well-established counsel with a great practice in the High Court, NCLT and Supreme Court. Thank you all for being here. This time we've tried something different since it's all about AI. Please take pictures of what you see here. This is a QR code where you can ask your questions. One of us will be moderating the questions asked, and those will be put to the speakers. Take pictures now because at some point when it gets into a presentation, you may miss out this opportunity. And now may I invite Saloni to kindly take the dais. Thank you so much, everyone. Big round of applause for Saloni, please.
Hi all, good evening. While the fun part and the demonstration will begin shortly, I'm just going to take 10 minutes of your time to discuss how to use AI safely and effectively. I'm going to pick up from where Nitin sir and Naushad sir left it last time. The question no longer is whether lawyers will be using AI. The question is how they will be using AI. I'd just like to add one word to that. How lawyers will be using AI responsibly is the real question now. So in the first session, the use of AI, the risks of blindly relying on AI for legal research and drafting were highlighted. In this session, I'm going to focus on how we as lawyers can use AI safely, effectively, and ethically. To begin with, I'd like to take the example of the Samsung semiconductor source code leak case. As you all know, Samsung allowed its engineers to use AI tools to resolve issues within its source code. In the process, employees input confidential data of Samsung onto ChatGPT, including the source code for the new program, internal meeting notes, as well as other confidential data relating to hardware. Within less than a month, there were 3 reported incidents of employees sharing sensitive data through ChatGPT. What did this do? It basically demonstrated how confidential business information quickly moved out from the organization's control. In response, Samsung Semiconductors is apparently creating its own internal AI. So the lesson here is very clear. The allegedly free AI services can come at a very expensive price, especially for lawyers whose entire practice is built on professional ethics, which include confidentiality, protection of the client's data, and preservation of legal privilege. In this matter, there's a famous case of R. Munir versus Secretary of State for the Home Department by the Upper Tribunal Immigration and Asylum Chamber of the United Kingdom in 2026. This is important, so I'm going to quote it. Uploading confidential documents into an open source AI tool such as ChatGPT is to place this information on the internet in the public domain and thus to breach client confidentiality and waive legal privilege, and such conduct might itself warrant referral to the regulatory body and should in any event be referred to Information Commissioner's Office. So now we know that inputting data on an open AI is a breach of client confidentiality. So what is the solution? Do we stop using AI altogether? I don't think that that is realistic at all in today's day and age. The better answer is to use AI using carefully defined guardrails. The Honorable Kerala High Court has come up with a policy regarding rules of use of artificial intelligence tools in the district judiciary in 2025. What does it say? AI use in courts must be transparent, fair, accountable, privacy protective, and proportionate to the risk involved, with heightened safeguards for sensitive or high-impact judicial tasks. Cloud-based AI tools should generally be avoided where confidential information, privileged communication, or personal data may be exposed. From Cyril Amarchand Mangaldas' standpoint, I'm going to get into how the firm uses AI and how it protects its clients' data in any event. The first thing that I'm going to cover is how does the firm use the AI and still protect client confidentiality. The Legora is the AI that the firm uses, and it is supported by CaseMind for case law research and Copilot for business services. We have adopted these systems with confidentiality as the top priority. So how do we do this? 1, client information is processed only by tools that are approved by the firm. All other AIs are blocked. We cannot use ChatGPT while we have access to client data. No output from AI is sent to clients without the lawyer threadbare reading the entire thing. Access is very strictly managed. Only authorized users can access it through our single sign-on integration, which means you have to use the CAM user ID and password to be able to access this. Security is reinforced with yearly audits. And an innovation team oversees the entire AI policy adherence. Now, the question is, does Legora actually ensure that our documents remain confidential? Yes, they do. And how do we do this? Is by a very robust contractual framework with Legora. All uploads, queries, and AI responses are treated as sensitive data, managed for confidentiality and integrity. Contractually, Legora uses our data only to run queries and generate results. This means it cannot retain the data, it has no direct access to it, it cannot train its models on the data that we have input, and it deletes it permanently when we ask it to. For sensitive issues, these are generally governed by our own established safeguards. What does that mean? So we held back on the Legora mobile app because Microsoft had not given us the required security controls that we would have liked. Now, the next point. Does the firm disclose to the clients that it is using AI? Yes, absolutely. I think this is where we will all benefit. If AI is being used, the clients need to know that it is being used. The firm provides clear information to the clients. It is part of our mandate now. Client concerns are immediately addressed, and most important, the consent and opt-out option. What does that mean? Clients can tell us that they do not want us to use AI. They can tell us you will stick to the old model of working, you will not use a single AI tool. So what are the broad takeaways from this? To ensure that AIs have clear measures in place to preserve confidentiality and maintain professional responsibility. 1, firms or individuals need to have AI policies, robust AI policies, and ensuring adherence to the same. Each team member must acknowledge this policy and the required training must be completed. Second is disclosure and consent. Clients must know that their sensitive information is going to be put into AI, and a straightforward option to opt out of this must be available with the client. Vendor contracts. Have a contract with the vendor that you are doing and ensure that the terms comprehensively include clearance, the no training from client data clause, as well as the deletion of the firm's confidential data clause, and a continuous verification. Audits are now available. There are companies which are giving services which audit whether your AI is actually safe or not. It is only after doing all of this that a firm or lawyer can instill confidence in a client to permit the use of AI. To conclude on confidentiality and the use of AI in legal practice, it must always begin and end with the client's trust. AI should be used only through approved secure platforms with clear policies and appropriate client consent. Strong vendor safeguards and independent lawyer review of every single output. If these safeguards are followed, AI can support our work without compromising confidentiality, privilege, or professional responsibilities. Apart from the confidentiality bit, again taking from where the last session ended, I'd like to end with a little word of caution, particularly for young advocates. AI can assist us accelerate our work and improve efficiency, but it cannot replace the discipline of legal thinking. In the first 1 or 2 years of practice, and Vinodni disagrees, but I do believe that in the first 2 years of practice, advocates must train their own minds first. They must learn how to read a brief, identify real legal issues, test a proposition, understand why precedents apply or do not apply to a case, and develop judgment. If that foundation is outsourced to AI, the risk is that we may produce answers without developing any understanding. Therefore, the responsible approach is not to reject AI, but to use it at the right stage and in the right way. For young lawyers, AI should come as an afterthought, not before the thought. First, use your minds, then use AI as a tool to refine, check, and assist. This is how we preserve the core values of our profession, being confidentiality, independence, judgment, and accountability, while still embracing the benefits of technology. Thank you. Ankita will now speak a little bit more on this and individual lawyers and protection of confidential data.
Good evening, everyone. Thank you for being here, taking out your evening. I'll start with a disclaimer, as all good lawyers should. Not that I'm professing to be an expert in technology or using AI in everyday practice. I think that role, of course, today belongs to Viraj and Vinodini, who will take you through the mechanics of how to use AI. But what I do want to speak about, because I see a lot of practitioners here in the High Court and in different courts, in how I and people like me, individual lawyers, have been using AI in practice, and how it is helping and perhaps not helping us so much in different aspects of practice. So I thought I'd divide the use of AI in practice in 3 parts. The first part being the reading of the material that all of us face as lawyers on a daily basis. The second part being the assimilation and the research of what you may have to do for a matter, for a brief, etc. And the third is the output, that is whether in the form of a draft or in the form of research or in the form of legal arguments that, or factual arguments that you have to advance in any court or tribunal. So in these three aspects, I have found AI helpful and unhelpful at different levels, and I'll just indicate what my experience has been. Just to, I think it will sound a word of caution, and it will also explain from my perspective or an individual lawyer's perspective how AI has assisted me. As far as reading and assimilating the material is concerned, I find AI an extremely effective tool, because of course it reads faster than any human can read. It assimilates, gathers the material, puts it in a tangible format far faster than any human being can do that. To give you a practical example of it, if I had to read a 1000-page brief and produce a list of dates from that brief, it would probably take me 5 to 6 hours. But AI, the minute you scan the documents and you ask it for a list of dates, it'll give you a fairly accurate list of dates in perhaps 20 minutes, 30 minutes of you scanning the material in AI. So that is as far as the assimilation of the material is concerned. Now I'll pause here and I'll explain the pros and cons. The pros is, of course, that you've cut down your work time by a large percentage. Right? You also have a fairly accurate, and I want to say depending on what software you're using Claude, you're using ChatGPT, the paid version, the unpaid version, etc. You're going to get a very good output, probably 80 to 90% accuracy in that output. But the flip side is that it has obviated the need for you to go through that 1000 pages and pick out the nuances that you would have as a trained lawyer, not just in education but in practice. So for instance, AI would give you a list of dates which would equally emphasize every aspect of every correspondence that you have gone through, every conveyance, every agreement, every document that you have gone through. It would give you an equal analysis of each and every document and put that in a list of dates. Now that's very good if you had to submit it to your perhaps law firm partner, you were working in a law firm. It's very good because it gives an equal analysis of every bit of documents, every bit of those 1,000 pages. But if you're a lawyer practicing who's getting ready to argue that brief tomorrow in court, you know from your years of practice that you actually don't need every item to be in that level of detail. Neither you have the time, nor does the judge have the time, nor is the emphasis in fact required. You may find that only 4 documents are required to be shown, and the list of dates really must in that sense concentrate on those 4 documents. So what has happened? You have got an analysis, but that does not mean that you do not have to read those 1,000 pages. All it means is that you have a blueprint. You can keep the blueprint on one side, you still have to go through that material and then see what from the blueprint you want to use with how much emphasis. So that is my first bit of feedback. I'm not going to say advice because I'm too junior in here to give advice to anybody, but that's my first bit of feedback to anybody here is that it does not obviate the need to read, and please do not use it as a replacement tool to reading. It doesn't do the reading for you, right? Because human beings are not like machines, right? We are not just reading as a computer would read. We are actually analyzing every word as we read. It's almost a subtext in our mind to keep analyzing as we read and to segregate what we think is important from what is not important. That is one. Second, now let's come to research. In research, I actually find AI to be far less useful than I find it in any other aspect of using AI. For the reason that research is a very analytical based approach that every lawyer uses, right? You start looking up on SEC, Manu Batra, Case Mine, any of this, and you go from one topic. The topic itself may suggest to you another branch of research which you haven't thought about. Let's say you've read one judgment which may not be relevant for your proposition, but that judgment has given you an idea which was not in your mind earlier, and then you go on to another branch. Now that is something that AI is not capable of doing, at least not yet. So, and also, if you start by using AI, right, you are boxed into the mindset that, oh, I have already found 3 cases, now it's okay, this box is checked in my preparation for this matter, let me move on to my next matter. So that's a little dangerous. It's also dangerous. Why? Because it's very easy for lawyers, who are busy as we all are, to quickly move on to other matters. This brief is done, let's close it, let's move on, right? The reason, and that's dangerous because you have then handicapped your mind from looking at material and giving itself ideas that it would have otherwise got had you not had that AI tool. So again, AI-based research is something I actively refrain from until and unless I finished everything. I have looked at it, I've looked at all the material, whoever's helping, assisting, whether it's my juniors or the attorneys, they've sent me the material, and then over and above that, it's almost done as a checking exercise at the end, like checking the box that, oh, now let me see whether AI gives me something over and above what I have already found. And that is the only aspect of AI vis-a-vis research is what I found useful. Though in fairness, I must say, the other thing which AI is very good at, which perhaps as lawyers and human beings we may not be as quick as, is to identify statutory and regulatory material, which it does way faster than most humans can do. Where, in a given matter, you have 3-4 different regulations, acts, etc. that apply, AI will call out the different provisions for you, the different acts, etc. But again, in that the nuance, which I do want to draw your attention to, is the fact that when you read the text of the statute, the regulation, the rule yourself, it does give you ideas to connect different parts, which is not a part of the analytical thinking that an AI does. And why is that? I mean, the reason becomes clear to you immediately. AI works on patterns. So it recognizes patterns that it has seen earlier and it picks out those patterns. So every time a lawyer sitting in India or a lawyer sitting in America, Australia, London, wherever is doing some research, it will retain that pattern. Then somebody else from another part of the world is doing something similar, it will cough up that pattern. So that's how AI works. But human mind works analytically to connect the dots of things which would otherwise seem unconnected completely. And so that is the big difference which research based in AI has shown to me at least. Now the last piece really, and I think I'm probably running out of time. So the last piece very quickly for us practicing lawyers in courts and tribunals is the preparation to argue your brief in court with the help of AI. Now there I find, at least as of today, of course Vinodni and Viraj will correct me if I'm wrong, but for myself, I find that that preparation is entirely irreplaceable by AI. AI cannot assist you in preparing your submissions for court, and you should not take that assistance for the simple reason that you from your experience knows that there are so many invariable factors when you go to a court to argue the matter. The first invariable factor is the judge. Every judge reacts differently. The second invariable factor is that you as a lawyer have picked out what you think are the 1, 2, 3 or a half a point in a matter. Third, what your opponent is going to argue. You may know some aspect of what he is going to argue from the pleadings that have been filed, but what he's going to say in court is entirely unknown to the AI tool, but it will be known to you. But the point is that if you have shut your mind in preparation, in anticipating what your opponent will say, then by using AI, then you will be totally unprepared to do it in court. And that is something that you should not handicap yourself with. So my takeaway really is this. AI is a great tool. I would recommend it to everybody. You can't not use it in this day and age. It's like after COVID, we all moved to an e-brief and we started using liquid text or good notes or PDF to argue our matters. And there's a big move by the Supreme Court to propound that. And of course, it has made our life extremely easy. We carry tens of thousands of pages of briefs anywhere that we go, right? And it saves paper, of course. And similarly, AI is now, it's in our lives. It's going to get better and better and better and better. It's a thinking software. It's not just a assimilating software. So we must start using it, but we should be very careful that it doesn't become a crutch. It's only a tool, just like SEC is a tool, just like our books are a tool, just like any other infrastructure is a tool. It's a tool. The mind is really yours. Thank you so much. Thank you so much. The really exciting part of today, which I'm personally looking forward to, is hearing from Vinodni and Viraj, because they are doing two things for us. One, they're going to explain few concepts pertaining to the use of AI in everyday work for lawyers, which is really exciting because I frankly feel like a bit of an illiterate every time I start using a new AI tool or a new AI software. But the more important thing is that they're going to give us practical tips, which is why we have this, they have a machine with them. They're going to give us practical tips on how to use AI in everyday work. So, Vinodni, if you can, sorry, Viraj is joining us first. Viraj, please come. Thank you so much.
Should we move on? Yeah. All right. So we are going to talk about actually in the trenches, if you are using AI today, how do you use it in the right way? Think of it as a how not to use AI more than how to use AI presentation, right? And I want to start with this iconic picture, because if you have been using AI like it's a genie, then that is the one thing that you should be taking away from today, is that stop doing that. If you are asking a question to ChatGPT or to Claude or to Gemini and you are expecting magic to happen, then that's the wrong way to look at it. AI is not a genie. So how do you think about AI, and what is the correct analogy to think about AI? Think about AI like it's petrol, right? It's a highly potent and volatile substance, that when used in the right manner, with the right tools, can move you from place A to place B. But if you are going to sit on a barrel of oil and light fire to it, then you are going to be in danger. So the whole purpose of today's presentation is to shift you from the left to the right. So that when you are using AI, you are using it with the right tools and the right safety protocols, so that you don't burn yourself in court or before a client. So before we get into the actual practice, I think everyone needs to understand 3 core concepts about AI, right? The first is that it predicts, it does not know. The second is that it is not a one size fits all. There are different models, they have different efforts, and they have different modes of working. And the last is the prompt, right? So if you come to something that I tried in the last week is I took one of the smaller models called Haiku and I switched off access to the internet. And I asked it, who is Sachin Kambli? And it gave me an answer is that Sachin Kambli is a professional cricketer. Nobody in this room knows who Sachin Kambli is, but Claude does. And there's a reason for that. Because what the model is doing in the background is it's giving you the most plausible answer, it's not giving you the correct answer. What it's telling you is that it's going through the entire internet that it has digested before it was published, and it knows that the word Sachin, the word Kambli, and the word cricketer are very closely connected to each other. So when you cut the 2 cricketers' names and join them, the first connection that it makes is that it's a cricketer. And that's why it gives you that answer. So it is predicting what is the next best word given the first few words that I have been given. And in order to make that prediction, it is going through its entire training data, which is practically the entire internet since it ever existed. But what does that mean? That means that there is no truth inside this model. There is no idea of what is right and what is wrong, what is true and what is false. It's simply predicting what is the next number going to come when you are rolling the dice, based on the previous rolls of the dice. And that's why it's very dangerous for lawyers. Because it will take one party name that sounds right, connect it to another party name that sounds right, add a reporter at the end of it, and very confidently tell you that this is a judgment on the point that you are looking for. And that's where, if you don't know how to use it properly and how to verify what it gives you, you are going to cite that in court and it's going to become a problem. So how do you do this, right? First thing that we need to understand is that there are different models out there, and different models were designed for different use cases. Think of them as a brain. There is a small brain, there's a big brain, and there's an even bigger brain, right? So if I were to take Claude as an example, Claude has a model called Haiku. Haiku is the smallest brain that Claude has published. If you are using Haiku for legal research, you are not going to get the greatest answer. The next brain is Sonnet. Sonnet is slightly bigger brain than Haiku, but that doesn't mean that it's the best brain out there. The best brain out there would be, say, Opus or Fable. So firstly, if you are using the correct brain, and for lawyers, I think by default, the bigger brain is the correct brain, you are likely to get less of a wrong answer than if you are using the smaller brain, right? The second thing is that the brain needs time to think, and in AI language, that's called effort. All these AI providers have an option for how much effort they should spend on the query that you have given them. They start from low and they go all the way up to max. There are different terminologies used by different providers. What they call default is, for example, say high. High is actually low, and you have to be careful about that. So if you are asking anything or you are doing anything, you should try to tend towards the greater effort level rather than the lesser effort level. Because the more effort that it puts into it, the more it verifies its own answer, and the more it thinks about what it's telling you before it gives you the answer. The last thing is the mode. right? Because it's not just what the brain is and how much time it spends on the answer. It's also what it's looking at before it gives you the answer, right? If you're connected to AI and you are asking it for an answer without connecting it to the internet, which is the first thing where it has no access to the internet, is going to do a Sachin Kambli, right? If you give it internet access, it's probably not going to make that mistake, because when I will ask it who is Sachin Kambli, it's going to go online, it's going to come back, and it's in all likelihood going to tell me there is nobody called Sachin Kambli. I think you are referring to Sachin Tendulkar, or I think you are referring to Vinod Kambli. But there is another mode which different people use different terms for. I think it's called deep research on Claude. Just go back. Yeah, it's called deep research on Claude. This is an iterative mode, right? If you use a deep research mode, it doesn't give you an instantaneous answer. It gives you an answer after 10 or 15 minutes of you putting your query in. And if you're using a deep research mode, that means it's actually getting an answer, going back with that answer, finding new things, getting the second answer, going back to the internet with that second answer, finding new things, and finally synthesizing it and giving it you a detailed report. If you are using deep research, next slide, again, you are basically reducing the possibility of making mistakes or getting hallucinations or getting the wrong answer. Now, one more thing that we need to remember is, if you go down, next slide, is that there is somebody out there who is trying to make money out of this tool, right? They have a budget. The more effort that you make their models do, the more money they are burning. So in order to make it efficient and economical, they are designing their models more and more to do less work. So while they pretend, or they say that they are doing more work, they are actually throttling their compute so that they give you answers using lesser effort. And when that happens, you need to be aware that not only are you picking the right model, but you are also breaking down your task into smaller subtasks, so that effectively you are making use of more compute and you are making use of more power of the brain than you would otherwise. And we are going to explain to you what it means by breaking down the task into smaller subtasks later in the presentation. The other thing that you have to be careful about is the framing. And this is very important. If you draft something and you give it to AI and say, this is my draft, what do you think about it? You're going to get a very, very positive answer. It's going to tell you, fantastic job, you're the best lawyer in the world, I have never seen a better draft than this. Great thinker, you've covered all the aspects. Oh, but there are these 2 to 3 things that you've missed out, why don't you add those? If you put that same draft and you say that somebody I don't trust has given me this draft, it's going to give you a completely different answer. Because that is how it starts thinking in its prediction. So the first words it reads are that somebody I don't trust has given me a draft, so it looks at it far more critically. So if you are testing one of your drafts or you are testing any of your output and you want input on that, it's better to frame it as the converse than to frame it honestly. You can in fact use this in another way, is if you get something from AI and you insert it back in another window and you say, I have done something like this, I am not very confident about the answer, can you verify if this answer is correct? It's going to look at its own answer as if it's yours and give you feedback on it, right? So it's very important to understand that you have to pick the correct framing depending on the output that you want. And if you pick framing, it's basically all AI models tend to veer towards the sycophantic, right? They are there to please. So it's important to use that intrinsic trait of AI to your advantage by flipping it and using it in a way that it points out the problems and it doesn't just keep patting your back. The other thing, and this is very important, is when it comes to breaking down the task. If anybody has ever uploaded a PDF file on AI and expected that it will do anything worth any value, then you're wrong. It's as simple as that. When you upload a PDF file into any of these AI models, they will spend 80% of their effort just trying to decipher that file. They will download some tools to read a PDF, then they will convert that PDF into text, and by the time they've done all this, they have already used up most of their effort. They are actually never going to read the file that was given to them in the first place. So if you are going to input something into AI, please make sure that you do it in two parts. The first part is you upload the file and you simply say convert it into a text file. After you get the text file, you upload the text file in a new window and you say now let's do the analysis, that whatever analysis it is that you want to start with. That itself will change the quality of the output that you're getting. AI does not understand PDFs. Lawyers work with PDFs. AI does not understand PDFs. AI understands text files. And you flip this with output. Let's say you are generating output using AI. You have to be very careful about what is the methodology in which, or the format in which you are asking for the output. If you are asking for the output in a Word document, then again, AI is going to spend more than 50% of its time trying to understand how to make a Word document, then trying to understand what is the formatting of the Word document, then trying to generate the Word document and verify the Word document. And it's not going to do the job that you asked it to do in the first place at all. It's going to get distracted. So you should try and ask it to give output in HTML. Because it knows how to use HTML, it has been trained on HTML because it's been trained on the internet. Once your output is finalized, it is only after that that you should convert it to docx. Because then the task of making the content is completely disassociated from the task of formatting the content and packaging the content. So you're spending more time, you're spending more of that resource in doing the content and less of the resource in doing the packaging. Now, we are going to run you through two use cases today. The first is research and the other is dictation. And for this presentation, we did an experiment. We took one question and we put that same question, identical phrasing, through 4 different models, efforts, and skills. And I'll explain what those are. So what did we do? We asked the same question. Are landlord-tenant disputes arbitrable with respect to properties in Mumbai? And we asked that 4 question to 4 different people, right? We asked that question to high effort. All of this was Opus 4.8. We asked it on high effort. We asked it on max effort. We asked it on max effort plus deep research. And we asked it on max effort plus deep research. Plus, we used the skill that we had created called the Indian Legal Research Skill. Now, let's look at what the answer is first. An answer generated by a human without using AI. That answer is a complicated answer. So, a tenant protected by the Rent Act, it's not arbitrable. The Maharashtra Rent Control Act applies. A lease deed under the Transfer of Property Act, now the law is that there is no protection to arbitration. So if you are in a lease that is not protected under the Rent Control Act, there is no protection from arbitration. A leave-in license is slightly more complicated. If it's a possession-related dispute on leave-in license, then according to me, the law is that it is not arbitrable. But if it is a non-possession related dispute, a dispute relating to security deposit, etc., the law is that it is arbitrable. And there is a judgment of the full bench of the Bombay High Court in Central Warehousing, 2010. That judgment is in appeal before the Supreme Court. That appeal is not yet decided. Central Warehousing says that 41 of the Small Causes Court Act bars arbitrability on all disputes covered under Section 41. That law is now unclear because that is under challenge and that has been watered down by a research judgment of the Bombay High Court. So if I am running this query on these 4 different AI bots, I want an answer that is similar to this. I want to test it to see if I get an answer that is similar to this. And I know that a good answer will have at least these 10 things in it. What are these 10 things, right? The first is the Transfer of Property Act, the Rent Control Act, the Small Causes Court Act, the Arbitration Act, Central Warehousing, Himangini Enterprises, Vidya Drolia, BXI and Office Parks, WeWork, and Motilal Oswal. If a junior lawyer, a first year graduate comes to me with these 10 things in their research, I'll be very happy with the answer. There may be another 100 things, but if these 10 things come, then I'll be very happy with the answer. So let's look at how they performed, right? The first model, which was on high effort, got 7.5 on 10. It identified these 7.5 things, right? The second one got 8. The third one also got 8. And the fourth one got 9.5. I am not looking at the answer. I am just looking at whether these things existed in its output, whether these things were mentioned. Just on that, this is the scorecard. But there's a problem here, right? Even though they may identify the right things, their answer is not always right. If you turn to the next slide. The first one completely missed the Motilal Oswal judgment of the Supreme Court. It missed it. It never found it. It went on and gave me an answer without reading that judgment at all. It also got a judgment wrong, the Dimple Enterprises judgment. It gave the wrong month. So it said June or something and the judgment was in April. The second one was sharper. It was more confident in its answer, but it actually hallucinated a judgment. This judgment did not, the number was wrong. It missed an important judgment of the Bombay High Court. A very recent and important judgment it missed. The third one was honest because it was in deep research. It was honest because deep research teaches them to be honest and tells them if you don't know, say you don't know. But it missed the two recent Bombay High Court judgments of WeWork and BXI and Office Parks. So it again didn't give the correct answer. And it got a single judge ruling was labeled as a full bench ruling. So again, it got something completely wrong. And then you look at the last one, which is deep research plus a modified skill. It gets to BXIN but doesn't name it. So it gets the principle of the BXIN judgment, which says that even after Vidya Drolia, leave and license disputes covered by section 41 are still not arbitrable. But it didn't name that judgment. And it extended Dimple Enterprises to licenses, which is also wrong because Dimple Enterprises says that this judgment will not apply to licenses and it will only apply to leases. So all four of these outputs look thoroughly professional. Like if you read the report, the language that is used, the structure that is used, the manner in which it describes judgments, the formatting, it looks really fantastic. But when you analyze it in detail, you will realize that all of them have made mistakes. Some of them have made fatal mistakes. And the fact that even though they are all different, they've all made mistakes is something that you need to keep in mind because whatever output you're going to get, these mistakes are inbuilt into that output. Vinodni will take over from you.
So if they all make mistakes, what are you supposed to do? Because the answer, according to me, is not that you don't use it at all, but you use certain guardrails to see how to prevent these mistakes from occurring. Three things that I would say are the cautionary guardrails when you're using AI for legal research. First, as far as possible, use the deep research mode. Why? Two critical reasons. First, it forces the AI model to give you links in its report to all the claims that it's making, and it actually gives you a link to where it has sourced that claim from. Just by glancing through the report and seeing the links that it has relied on, you will immediately know, has it got it from a blog post, has it got it from a newspaper report, has it got it from someone's Facebook post, or has it actually got it from the judgment. So first line of filter on trust. Second, deep research works iteratively, in much the way that we do research, in much the way that Ankita had described we ought to do research. In that it first starts with your query, it goes into the internet, it finds something, let's say it finds a judgment, the judgment refers to a statute. In the second line of iteration that it does, it factors that statute in, and that makes a difference because that improves the quality of the output you get. You don't want somebody who, the equivalent of a lawyer going and again researching, maybe not getting to a perfect answer, but using one judgment to inform the next search, and that's very critical. The third thing that we found very useful while adapting deep research to use it for our purposes is to write down a skill. What is a skill? A skill is a detailed set of instructions that you give to AI. Skill is the nomenclature that Claude uses. There may be other nomenclatures that other providers use. But you give it a detailed set of instructions on what you want it to do. You don't just go on deep research mode and say, now please look at whether landlord-tenant disputes are arbitrable. Now to what detail must you go? Let's go to the next slide. 4 or 5 things. We've given you some extracts of the skill. It may be easier to see using the QR code on the phone. The first thing to do is define who it is. So tell it, we have told it you are an expert Indian legal researcher. Alternatively, you can tell it you are an advocate with 10 years of practice, 20 years of practice. But do set a baseline for what role it must adopt. The second thing is don't give it a vague adjective on what to do. Set the standard for the work. So imagine for a second that you're a bureau setting standards and tell it what good output would look like. So I would, what the words we have used are, we have told it, we've not just told it be thorough, we've told it be forensic, be deep, be exhaustive, do multi-pass, which means we are making sure that in our instruction we have specifically told it, please don't opt out of iterating, we want you to iterate. The third is tell it what not to do. So we have specifically told it, do not give us surface level summaries. So for what it's worth, we have shared this skill with you at the end of the presentation. You can all look at it, refine it and use it. But this is just to break it down so that you can apply this to other prompts that you may use. The next slide. The next thing that I would strongly recommend is quantify what baseline output looks like. So don't say, of course we have said be forensic with the proposition, but we've also gone ahead and said that please make sure that you give me at least 10 judgments on each variable, unless the doctrine is so sparse that 10 judgments are not available. Why have we said this? Because I do not want it to find the first available link with the first relevant judgment and stop there. I want it to give me as many leads as possible. The next thing that we have done, and which I strongly recommend doing in any legal research prompt, is guardrail where are the sources that it has to look, so that it doesn't end up looking at newspapers, at blogs, at social media posts. Specifically tell it to look at particular sources. So we have given these sources. We've said look at Indian Qanun, look at CaseMine, look at SEC Online. It doesn't have access to paid databases because we are using a generic software. But what it can access on the internet, perhaps the published INSC reports of our Supreme Court, PDF links to judgments published by the High Court. These are things that it must be accessing and that we must tell it to access. Next slide. Then we have spent a considerable amount of time telling it what we don't want it to do in the output, so that it doesn't waste time when it finally gives me the answer, telling me, I looked through 300 web pages, I did this, I did that. Not interested, that's not what a lawyer wants to know. But therefore we first have told it, do not describe or narrate the research process. Do not merge findings across different legal questions I have asked you. Don't force fit judgments into a variable just to hit the 10 variable protocol because I told you to get 10 judgments. If a judgment has been overruled, say so. And it will say so only if it knows so. And finally, we've told it in what form we want the answer. Because otherwise, it is going to take the liberty to write the essay of a first-year law student, which you don't want to read. And therefore, we've said, set out the current legal position. So summarize it. Summarize all the relevant statutory provisions you've looked at. Give us a table with all key judgments you have found. Give me the full citation. Give me the code. Give me what you think is the ratio. Now, the question though is, next answer. Because I have given such exhaustive information, how do I deal with this output? Do I trust it? Does this mean that I get this memo of citations from whichever AI software I fed it into? I take it, I open the first 3 links and I tender them in court? No. I would say, please use this as your first blueprint. The strength of AI is that in those 20 minutes that the deep research model works, I've regularly seen it hit anywhere above 200 links, and its ability to look at that is unparalleled. As an individual, as a lawyer, however good you are at legal analysis, you can't look at 200 web links in 20 minutes. That is its strength, so leverage it. But what is it giving you? Think of it as a lead generation task. It has given you relevant links, and that is where its job ends. How do you now work with the output that you get? 3 things before that. What are you aiming for? What we are aiming for is a first cut. We are aiming for a lead generation protocol. In other words, if I were to give you a crude example, if I were a salesman thinking of who all I can make sales to, this would be a phone directory that I maintain on who I can call to sell my software to. That's it. Beyond that, the process has to be owned by the lawyer. Links have to be opened by us. Follow-ups have to be done by us. The checking, the analysis of the judgment has to be done by us. So I would then say, I want to therefore first analyze what I do after it answers before I go back and explain what are some of the things that I would do to tailor the question to get better answers. So that's the right part of this slide. First, read. Should you read what it gives you? Yes. But how? With a healthy dose of skepticism. If it tells you a case exists, don't believe it. Look for the link to Indian Qanun or SEC online or to CaseMine. If it tells you that a judgment says something and it seems to be exactly what you want, definitely don't believe it. Most likely it's wrong, and there is some paragraph in the judgment which says the opposite, maybe the facts don't apply at all. But note the link down anyway because it's a potential lead. And then what do you do with it? Read it anyway, for thoughts, for sometimes just to see how comprehensive it is. And sometimes when you make the read, you will be able to find out which are the parts where it has cited nothing at all, which you know pretty much has come from its own reasoning. There you mark it with heavy skepticism. And where it seems to have actually read the primary source, a link to an actual judgment, where you can say, okay, this seems to be a strong lead and I must pursue it. Once you have garnered the leads, once you have garnered all the links from the judgment, I don't think there is any substitute to actually opening and reading that judgment. Read it. And the third thing that I would say is, therefore, open every potential link, read the judgment. First, I would say what I do generally is I quickly skim to the para that AI says it has relied on in the judgment, just to check if what it has said is exactly the opposite of what the judgment says. So that's my first filter. And then I filter down the judgments that I actually want to read, and I read them. And I don't think there is any other shortcut to that. The other thing that you must do, which it doesn't do, is an authority check. It does not go on the website of our High Court to check if there is a division bench reference or appeal pending. It certainly doesn't go on the website of the Honorable Supreme Court and check either. That is something we must be doing. The third thing that I do is generally once I read and I have the first set of links of the judgments, I now have a vision of how the research must go forward. This is the same thing all of us do when we research on SEC, where we've seen 10 judgments, 20 judgments, and we know what we want next. But if I want to get the best results out of AI, I run the search again. And that, let's talk a little bit about how to run that search again. First, I would say, frame your legal question neutrally in your first search. So don't ask, give me judgments to say that landlord-tenants disputes are arbitrable. Because then you've told it to look for a particular type of output. If there is a Supreme Court judgment saying the exact opposite, it will not find it. Most likely it will not find it, and that is a risk. Therefore, frame your question neutrally so that you get information on both sides of the spectrum. The second thing that I have seen is, if not on the first run, at least if you're doing a second run to refine things, give it your facts. It improves the outcome substantially. Pare down your facts, don't give it party names, just give it a very brief overview of what your case is and what the central point that you're going to argue is. That improves the output. The third thing that I have seen that really helps in terms of ideation is, on a separate thread, not the thread where you're doing research, separate window, give it the facts again and say, draft me a prompt to conduct legal research on these facts. What it will give you is a laundry list of all the propositions that it thinks you must research. Should you research all those prompts? No. But it's a great way to brainstorm and generate ideas and to see if there are tangents beyond what you have thought of in the matter as you have read and as you have thought about the matter. Then you can select those questions that seem to actually have merit and pursue research along that direction. The other thing that I generally do is I then run the facts from the other side. I run it as if the other side were researching. So I give a brief overview of the facts on a new thread from a completely different side. Then I ask the prompt to give me, if I were to argue in court that these such disputes are arbitrable, I will say, in light of these facts, you research and find me judgments to say it is not arbitrable. So at least I know that I have covered my base in terms of getting a good set of links to judgments, which when I read, I can then develop into a comprehensive legal research memo for the purposes of court. Now that therefore deals with legal research. The biggest insight, please don't use it to say give me judgments and then take those judgments and cite them in court. Use it only for lead harvesting. That is what it is good at. If you have seen, it hallucinates, it miscites judgments, it interprets them incorrectly, it quotes irrelevant judgments, it will give you confidently judgments that have been overruled. So remember that risk, but it is excellent at trawling the internet. You and I will never be as fast as it, so do leverage it for what it's good at. The second thing that we extensively use AI for is to dictate. It's not possible sometimes to call a stenographer for every little note you want to dictate. Nor is it possible at 1 a.m. in the morning sometimes to ask a stenographer to be present, although some of them are very helpful and they do come. So then you can use AI for that purpose. But unlike a competent stenographer who already knows and who is trained to take dictation, AI has no experience, and AI loves to add to what you have to say. So if you say the plaintiff is so-and-so, and that's all you want AI to type, AI is happy to say that the illegal issue that arises in this case with the plaintiff being so-and-so is this, which is not what you dictated at all. Therefore, it's important to prompt AI correctly. The other thing that stenographers know instinctively, which AI doesn't know, is let's say you're dictating and you say the lease deed was executed on 30th. No, the lease deed was to be executed. Every stenographer would know this is a correction and he'll have to make a deletion and correct it. AI doesn't know. Most AI tools will either embellish what you have said or take down what they feel like taking down. That's a problem because you don't want to be checking the dictation to see if someone has actually taken down what you have. So what we've done is we use a protocol where we have spelled out in minute details instructions that a steno will never need, but AI does. And the reason I want to show it to you is because it signifies something useful about how to build prompts using AI. If you can just go to the next slide. The instructions to AI are in 10 parts. The first is you are a legal transcriber. You are not the lawyer on this matter. You are to take down what I say. You are not to invent anything. You are not to add anything. You are not to supply legal analysis. Second, we've said when I say 1, 2, 3, please take it down as 1 dot para, 2 dot para. 3, please don't refine unless I ask you to. Don't refine for structure. Don't refine for clarity. But what should you do? Add only corrections for spelling, grammar, punctuation, and obvious errors in taking down what I have said. We've gone to the extent of telling it, if I say quote, you need to type a quotation mark. The rest of it has to come in quotations. The point of showing you this is to say that these instructions make it far more reliable to do something that a person can very instinctively do. And then, of course, we've saved this to whenever we tell any chatbot that we are using to activate this protocol, to activate it and use it, we've made it available to you. But what is the insight about this protocol is not what it contains, but how we actually drafted it. I did not draft that prompt end to end. All of us are lawyers, we have better things to draft than AI prompts. So how do we draft prompts? You have a basic set of ideas of what you want and what you don't want. With experience as you use it, you learn what are the mistakes that it makes. Consolidate all those thoughts and give it in a very rough form to any AI tool. ask it to draft a comprehensive prompt. In most cases, it is going to give you a very detailed and comprehensive prompt. So take your ideas, put them down as a summary and use AI to generate the prompt. That could be incredibly helpful in giving you a detailed prompt. Then you can settle or work around that prompt so that you get final output that you can replicate. That I think is true whether you're drafting a prompt for research, drafting a prompt for fixing typographical errors, for formatting your legal work, whichever way it is, you leverage AI to draft the prompt. Specify the clear core instructions. Don't spend hours poring over how to draft prompts. That is not what we are required to do. And therefore, that brings us actually to the close of the 2 use cases that we wanted to share with you. We also use AI for a wide variety of other things. Proofreading, formatting, bookmarking briefs as and when they come, because each of us has a different style in which we want to do it, and AI is incredibly good at doing such things. Sometimes just if I want to talk about a matter and I don't see a chamber colleague around, sometimes I do speak to it to sense test ideas or to push things to the extreme, to dictate in the car, to use Claude Code, so to make an app, to make memos for you. It's capable of a lot. But I want to end by saying what we don't use it for, and I think it comes back to that. I don't use it, I don't take out my phone and say, please give me a draft plaint in this matter. I don't take my phone out and say, please give me a list of dates. I think, one, it makes you lose the connection and the muscle memory to the matter and the thoroughness that reading your own brief gives. And second, it completely removes recall, because when you're standing in court, it's your draft, you've done it, you know where everything is. That is a very different level of familiarity with the brief than to have taken something from AI. Third, it takes much longer to correct a terribly made draft from AI than to just dictate a draft on your own, which is why we have shared the dictate protocol with you, and we are not sharing a drafting protocol because we don't think it should be used in that way. So that's it. These are 2 use cases. What we've shared with you, before that, a couple of things to maintain confidentiality of information and everything. There is 2 or 3 things that we would recommend. First, all of these tools have a option where you can turn off the ability to use your chat for training the model. So feel free to make sure that you go there and switch that off, because by default that is on, so that your data is not used in the larger training of the model. Second, if there's something so sensitive that you don't even want to dictate that one blurb of your facts for doing legal research, or you don't want to dictate your draft there and for any of that information to be out there, please do use a temporary chat or temporary mode, because that is usually not retained in the system for as long as other information would be. So that is some caveats about how to use AI. Yes, and the last, of course, is therefore, how do you approach AI? Just one big message: treat it as a very competent intern. Do not rely on it as a reflection yourself or something smarter than you which will solve problems that you cannot solve. It does not have the subtlety of legal analysis, nor has it read your matter well enough to be able to give you those kind of outputs. Therefore, use it for what it's good at and use it with a healthy dose of skepticism. Mistrust everything it says, but use it nevertheless. That would be, I think, the parting advice, as you could call it, that we would leave you with. So what we've done is these 3 protocols that we use, skills that we use, we've put it on a Google Drive link so that you can all access it and put it up on your own AI tools and see how it works for you. And of course, keep refining it and do tell us what changes you've made so that we can also work better with it. Yes, and I also wanted to thank Mr. Anosh Sequeira, who is in fact the author of the bookmarking skill. That's not our skill. And he has very graciously shared it with all of us so that we can use it, and that's going to save all of us a lot of time in making our briefs ready for court. So thank you, Anosh, for that. Thank you.
Thank you so much for being an amazingly patient audience. I know it was a riveting evening. Thank you, Saloni. Thank you, Viraj. Thank you, Vinodini. I really feel like I've gone back to, when I was much younger. My mom used to send me to classes to learn computer languages. That was the thing that had just started. I feel like I'm back at one of those, and it's been an amazingly informative evening. Very quickly, we have some questions from the audience who have scanned the QR code. I'll start with the questions that we've received, and then, of course, we'll take some from the audience if there are any. I think the first question is for someone who has no knowledge on how do I start, or no knowledge of AI, how do I start using AI? Vinodini, Viraj, you all want to take that question? Just with a brief answer. Yeah, with a brief answer.
Kashyap,
You want him to come here? You want them to come here?
Yeah.
Yeah.
So the answer, is it, am I audible now? Is it working? Yeah. The answer to how do I start using AI,
You want to come here? Yeah, come. Come. Till they work on that. Yeah, come.
now we made it loud.
yeah. So I think my answer to how do you use AI if you've never done it before is start using. It's a chat tool after all, you can just talk to it. Try using it for anything that you need. Ask it if you run into any hurdle. Watch YouTube videos. There are people far more experienced than us. There are CEOs of companies that actually own these tools who are giving you a tutorial on how to use it. It is not complicated. It's like using a washing machine or a microwave at home. So use it. Don't be intimidated by it. Just use it. And if you have any queries, the best part about AI is that you can talk to it and you can ask it, how do I proceed next? Where do I find this? Where do I find that? And it will tell you. So don't be intimidated. Just use it would be my answer.
Thank you so much, Vinodini. The next question, which we've got, which even I have, and it's a very pertinent question. So somebody has given an instance of Garfield AI, a company based in UK, which has enabled law firms to file their pleadings in court entirely using AI. And as a result, a lot of the law firms have indicated that they have no need for A0s or entry-level lawyers. I think Saloni can tell us how AI is affecting the law firm market and the young lawyers' prospects.
The young lawyers' prospects, I don't think are getting too affected by AI just yet, but young interns, yes. There is definitely a shift in using AI. We are seeing lesser interns being engaged by firms which have AI because, like Vinodni rightly said, we use AI as very, very competent interns. Does that mean we see no interns? No. There are lesser number. Competition is very high for the interns. But we definitely do not see AI today as a replacement for even interns. So yes, definitely competition is high, but not a replacement yet.
Thank you so much.
I just wanted to add something
yes,
here.
yes.
If you are a young lawyer, the worst thing that you can do for your career prospects today is to use AI at work.
Yeah.
To use AI to draft, to use AI to research. You first need to build that muscle yourself. Only when you know what a good draft is or when you know what good research output is, will you be able to judge AI's output for whether AI's output is good or not. So that's something that's very important.
Right. Since I see that we're running out of time and I'm quite cognizant that people have to be in court tomorrow. So before we end the session, I want to invite two very important people, especially from today's standpoint. These are the founders of Lex Legis, which is an AI tool which can be made available to every practicing lawyer. Can I invite Mr. Yadav to speak to us a little bit about it? Thank you so much.
Hi, good evening, everybody. Thank you for having me here. It's so nice to see that at least there is a session on AI here. About a year ago, when I used to talk to judges, etc., they used to all say that it's never going to happen. Most lawyers were not receptive. Uh, and nice words, hallucination, don't draft, don't treat it like this, treat it like this. I strongly feel it's all very confusing. Uh, Many parts of the law is going to be commoditized and productized. The very intelligent lawyers are going to have a lot of work to do because AI is definitely not going to replace lawyers. It's not going to replace the human judgment. But a lot of work that we do uh, is going to completely be consumed by AI. We spoke more about very generalized models, and therefore we heard about people talking about how to prompt, how not to prompt, and you could get it wrong every time because you may miss to write a sentence, etc. I have a few slides very quickly. I'll take up any questions if you want. More meaningful, more for education, nothing about lex legis or anything at all. All tools are good, all tools are nice. Whatever works best for you, works best for you. Uh, just to give you a brief summary, my journey in law started 90 years ago. My grandfather was a lawyer. My father was in a quasi-judicial post. I was in the National Defense Academy. I opted out. I was also later heading the National Judicial Reference System and have a lot of understanding on data, what's happening in the country at various courts, etc. And with that point, I want to start this point. My journey on the legal intelligence has lasted about 25 years. It's previous slide. 1998 was when we built the first search engine. 2004, we were building the largest database of judgments. 2014, I was heading the National Judicial Reference System. 2025, we built a very purposeful legal LLM for India. And now we are not only serving hundreds of law offices in the country, certain quasi-judicial posts, certain judges, etc., but we are also now entering outside India. Hallucination mostly happens because it's not backed by data, and somebody here rightly said because it has ingested a lot of data, and we back all our content with almost 14 million very curated, selected documents that are there, that basically forms the meaning of why we are giving an output. This is equivalent to, this AI is measured in words in terms of token. So approximately about 100 token is about 75 words, about 5 characters on an average. So we have about 20 billion tokens worth of data on which we are doing, and it's updated on an hourly basis. There's nobody else doing in the world right now. It's updated on an hourly basis. So somebody is speaking about sonnet, opus, fable, etc. So they usually, so a sonnet would be a Jan or October updated, etc. So when you use ours, you possibly be using yesterday's output, or maybe in some cases in the evening today morning's output. All right. So we have a feature called Legal Aid, AID. It stands for Ask, which is a legal research tool. We have I, that stands for Interact. When you have large sets of documents, we understand PDF very nicely. Scanned PDF, handwriting. You have, so we're doing something for Mantralaya. So they have handwritten Marathi word, and we understand it very nicely. So, English, Hindi, Marathi, vernacular, extremely easy. PDF is something that we just enjoy dealing with. And then drafting, extremely submission ready drafting, very high quality drafting that we do. So what is important is that most of our, in fact, majority of our work you will see backed up with source data and ensuring no hallucination. That's one of the biggest problem. No hallucination. We give you source references, and we also give you a reasoning chain as to why this. So even the recent Honorable Supreme Court's guidelines that they say that any AI has to be with a reasoning chain. So all our outputs is with a reasoning chain. It will tell you why we are giving this answer. And then we'll back it up with source references. And then you could see this answer without hallucination. So we now launched Mira, that's Machine Intelligence and Reasoning Agent. It's a very powerful agent. It's absolutely grounded, verified. You could ask it for drafting petitions, agreements, etc. And if she does not understand, she will ask you, I don't really understand which law are you referring to. I don't understand what do you want this as an output for. And she would come out with an answer. So don't worry about it not being neutral, etc. Or so for example, if you say that I want this judgment in my favor, it will not hallucinate. It will say, sorry, I don't have any judgment in your favor. All right, so it is very neutral, it's unbiased, and it will not hallucinate. So one emphasis from a very august gathering here was that these models are very probabilistic. All right, we specialize in making this probabilistic model because all of them, if anyone of them are you maths wizards, they all are vector embeddings. So we convert this probabilistic model into deterministic model by 4 pillars that are strength. We have the largest data. We mentioned, we heard SEC, Manupatra, case mine. We have the largest data set, and possibly in a few months, we're going to make a legal search, not research, not AI search, legal judgment search with majority neutral citations and original code judgments, not true copies, HTML copies, etc. Original, accessible to everybody, most probably free of cost. Because we don't believe that you should pay to access judgments of any honorable court, which is meant for all citizens, and it should be accessible for all citizens. So you got to get this, and you got to get with lot of data. You could actually drill down to a judge's thinking. You can drill down to a lot of network of backward-forward references, and you could analyze a lot of data. That's going to come out very soon. We have our own fine-tuned models back. We have our own very large 215 skill sets, so you don't have to define your skill sets. And we have very refined processes that you can use it. Next. All right, Mira are solutions. You're sitting in a court. You don't have a laptop. You may have your iPads with liquid text. How about using it on your WhatsApp? So what you could do, there's a number here, you could note it down quickly. You could ask a legal question, ask it to draft. It would give you a Word document here on WhatsApp. All right, you're confused about something, you could do it. A client has sent you a judgment, forward it to Mira's number and say, okay, please quickly summarize, let me know what to do. Is it important, not important, etc. And you could do it there. Next. It works in Microsoft Word. Grounded with case research, with agentic platform, with redlining, and et al. Next. All right, so we're launching Devil's Advocate. What's a Devil's Advocate? Very interesting number, very interesting name. Imagine having a system where you could upload, supposing you're the petitioner, you have submitted your documents, the respondent has replied, you are again going to the court. So you could actually upload all the response document, the petitions document, and you could write your own, whatever you plan to speak today, or whatever your plea is, you could write that. And then the devil's advocate would play your opponent's role and give you with citations, listen, you are wrong because of such things. And now you want to reply to that. So it will give you suggestions that, listen, you could do this, this or this. You could reply this, this or this. And then you could choose any one of them and see what the devil is. It's a great way of preparing before you actually go and face. So at the end, there is a facility for asking the judge to come. So it's an AI judge, no disrespect to any honorable judges, please. It's an AI judge, and it would then tell you how well did you do, who did well, and then what were whose weak points. Imagine that doing in minutes. Amazing tool. You could upload PDFs, scan PDFs, write your documents, and have a game there, And it's extremely powerful and extremely nice. You'll really enjoy using this. All right. another interesting thing. All of you have heard of this game called Truth or Dare? So, all right, so you got a document from somebody else, and there are documents and you don't know if it's hallucinated. So what do? You upload it to our Truth or Dare feature. All right, why dare? You find the truth, or you dare risk your reputation in front of a judge. All right, it will find out which ones are the verified citations, which could need a review, or which ones are absolutely bogus. So truth and what amazing feature. I mean, you'll just love all this feature. And these are the use cases which we are not asking. I mean, hundreds of users are using it. They're asking us to work on these features, and this is what we're giving. Next. All right, so this is available where you want. A lot of things here was spoken about general models, about Opus, ChatGPT, etc. But no one actually is in the market talking about client confidentiality. We at the end also showed, Madam spoke about, that you should put your, when you use a ChatGPT, if you're using ChatGPT, go to data controls, most of you will have the green button on, which says, share your question answers with ChatGPT to improve the model. Basically, I can take your data. So what happens to client confidentiality? And is AI only going to be limited to lawyers? Are the honorable judges not going to use AI? Are they only going to be visible on the web? So you have the data on SaaS that is on the web, absolutely with bank-grade security in India as per DPDP Act. Remember, if you're using cloud and a lot of features, you're also breaching the DPDP Act because a lot of data is going outside India. Now, what if you want to do it offline? How about a machine like this? This is a Grace Blackwell supercomputer, an AI chip inside. It has our fine-tuned models installed. It works without the internet. You can ask questions, you can draft. It cannot do case research for you because does not get updated regularly. But your document interaction and drafting, this is not a PC. This is a PC with an AI chip. So, I mean, we already are working with the defense, certain bureaucracy, certain judicial officers who are using it for drafting. Because I'm not expecting a gangster's judgment going to be drafted online and risking a Cambridge Analytica to happen. If you don't know about Cambridge Analytica, you could look it up. There is no breach of data on this. It works, it's air-gapped. Air-gapped means it just does not leave your desk. So this is on desk. You could have it on-prem. Law firms could have a larger machine. So this could support up to 20 users. So if you're working in a due diligence, a very confidential due diligence, you could just put it here, have it on the desk, and everybody sitting in a room and could just use it over a local Wi-Fi without the internet. And absolutely a very fine 120 billion parameter model. All right, next. Yeah, this is something for your interest. You may want to see this. So most models have these various parts. All right. So you have the document, you have the vectorization, you have the chunking, you have the retrieval, the LLM or the model weights, inference. This is what happens on on-desk. On on-desk, everything resides on your machine. Next. On-premise also, everything resides on your machine. Nothing goes out to anybody. Client confidentiality, 100%. Next. On a hybrid model, which everybody is right now selling to you, is the LLM and the inference happens there. That means the document does not leave, but your text of the document and the meaning of your document leaves your desk. So this orange part is the risky part. Next. And then there are broken hybrids in which certain vectorization happens on their machine. Then you do some work here, and then again the inference happens on their machine. Absolutely risky. Don't do it. Especially for confidential. I know you're drafting a rent agreement, go and do it anywhere. But you're drafting a listed company's takeover. Absolutely risking client's reputation. Absolutely. Insider trading, every risk that you can think of. Next. And then SaaS, then everything is online. Okay? So this is what most people do. but it depends on you how you want to do, what you want to do. Next, anything? Yeah, this is just a show. Yeah, that's all. In case there are any questions, happy to take it. Otherwise, Mohit Joshi is here. I can tell you Mohit is from Harvard, he's from MIT, he's done his master's in robotics. He's helping us to educate people here in the market. He's going to be here for the next few days. If you want to see a demo, please see the demo. You want to try it. Okay, the WhatsApp, this is right now not behind a paywall. You can just use it, crack it, dislike it, throw it away. And if you like it, please, it's an Indian company, 100% Indian company based in Bombay. I thank BBA to support us, and whatever we can do for you and for your members, we'll be most happy and very obliged to be here. Thank you, ma'am, for having us here, please. Any questions, please? Just one.
Whatever, does not include what is there on the Bombay High Court site. Is it true? And for a unpaid version, non-paid version, is that encryptment not there?
I don't think that's true. There is no feature that is lacking in the unpaid version, except the devil's advocate. You can access it because it's a costly model. You can access it, try it, but there is nothing that is not there in the free version right now. But we don't intend to make it free. We are not backed with American companies with billions of dollars, so we have to charge. Presently, it is free for people to try, but there's nothing that the paid version will have that what we are asking you to do on a trial is not there. Sir, I don't think, with due respect to the honorable courts, I don't think anybody is going to deny any drafting. The only emphasis which the Supreme Court has even said, that the onus of submission lies with the signatory. You cannot say that my junior had drafted it, therefore I did not see it, my honor. So in the similar way, you cannot say that AI has drafted it, and therefore I don't. The onus will always lie with the signatory in any law. So I think that's a very simple thing. It cannot lie with anybody. So we have to read it up. Will Bombay High Court allow? Why will they stop it? You are submitting it. They can reject it or there's no stopping of submission. They're saying, as a caution, don't use it. As a caution, reread. Because like somebody said, 1,000-page, you're not reading, you're summarizing, and you, based on what it is giving. RAI is much better, of course, but please read. I mean, there is no substitute for it's your reputation at stake. So, and your clients, what risk, I don't know, but yes, there's a client is at risk. So.
In one case, I have submitted the AI-generated drafting. And drafting, there are so many times it has to be cleared whether you're rejected whether you objection. That time he told that whatever the English you have used is like an American English, whether judges will understand.
Not with us, sir. You didn't use us.
Then you please draft your own mind and own languages, in Indian languages, not AI generated.
So you please use ours. It will absolutely be like our language. Thank you very much.
Thank you, everyone. Thank you for being here. Please join us for tea. And for those of you who are more interested in this topic, on 7th August, the BBA is also organizing another AI seminar, which is being done by another agency. So you guys can attend some more of this if it has perked your interest. Thank you for joining us today. Thank you.